What's considered a violent felony in Oklahoma? In Oklahoma, the term violent felony carries serious legal consequences. It affects not only how a case is charged and prosecuted, but also sentencing, parole eligibility, and whether certain statutory requirements apply. While the phrase sounds straightforward, Oklahoma law defines violent offenses in a specific way that goes beyond common assumptions. Understanding what qualifies as a violent felony is critical if you or a loved one is facing criminal charges. The legal definition under Oklahoma law: Oklahoma does not rely solely on a general description of violence. Instead, the legislature has created a defined list of offenses that are considered violent. This designation appears in multiple statutes, including those governing sentencing and parole. Generally, a violent felony involves the use or threat of physical force against another person, or conduct that presents a substantial risk of serious bodily harm. However, the controlling factor is whether the offense is included in the statutory list of violent crimes. Common crimes. Classified as violent felonies. Oklahoma law identifies a number of offenses that are treated as violent. While the full list is statutory and subject to change, courts consistently recognize several core crimes as violent felonies. These commonly include murder and manslaughter, robbery, particularly when force or a weapon is involved, rape and other forcible sex offenses, kidnapping, shooting with intent to kill, and assault and battery with a dangerous weapon. If you're facing charges for a violent felony, it's important to know what that means. Our Tulsa criminal defense attorneys can explain. These offenses involve either direct harm or a high risk of harm to another person, which is why they are categorized as violent. Why the classification matters: being charged with a violent felony has consequences that go far beyond the initial accusation. In Oklahoma, violent offenses often carry stricter sentencing rules and fewer opportunities for early release. Additionally, violent felony convictions can affect bond eligibility and pretrial release, plea negotiations, parole and probation options, and long-term criminal record consequences. The role of the 85% rule. One of the most important aspects of violent felony classification in Oklahoma is its connection to the 85% rule. This rule applies to a specific list of enumerated crimes and requires individuals to serve the vast majority of their sentence before release. While not every violent felony falls under this rule, many of the most serious offenses do. As a result, the classification of a charge can have a direct and lasting impact on how much time a person will actually serve. Charges that may seem violent but are not always classified that way. Not every offense involving physical conduct is automatically classified as a violent felony under Oklahoma law. Some crimes may involve confrontation or harm, but are not included in the statutory list that triggers enhanced consequences. This distinction is important because the legal classification, not just the facts, determines how the case will be treated. In some situations, the way a charge is filed or amended can significantly affect the outcome. Defending against a violent felony charge. Defending a violent felony case requires careful analysis of both the facts and the statutory framework. Key issues often include whether the alleged conduct meets the elements of the charged offense and whether the evidence supports the classification as a violent crime. In some cases, challenging the severity of the charge or negotiating a reduction to a non-violent offense can have a substantial impact on sentencing exposure and future consequences. In Oklahoma, a violent felony is not just any crime involving harm. It is a legally defined category with serious implications. From sentencing rules to parole eligibility, the classification affects nearly every stage of a criminal case. If you are facing charges, contact the Tulsa criminal defense lawyers at Kania Law Office by calling us at 918-743-2233 or ask a question online.